The first thing I saw when I turned onto the south access road was one of my ranch hands, face down in the gravel. The second was a man wearing an HOA security patch, pressing his knee between the kid's shoulder blades. I hit the brakes so hard, my government-issued Tahoe slid sideways in the dust. "Get off him!" Every head turned. 3 black HOA security SUVs were parked across the entrance to my ranch outside Red Creek, Wyoming. 2 more guards stood near the cattle gate with pistols holstered at their hips. My foreman, Luis Mendoza, had his wrists zip-tied behind his back. Beside him, 24-year-old Evan Brooks was on his knees, blood running from a scrape along his cheek. And standing in the middle of it all was Cynthia Vale, president of the Red Creek Estates Homeowners Association. She looked at me like I was an inconvenience. "Sir, stay in your vehicle," one of the guards ordered. I stepped out anyway. "My name is Daniel Mercer. I'm 51 years old. Most people around Red Creek know me as the quiet rancher who owns the 1,200 acres west of the new subdivision." What Cynthia Vale apparently didn't know was what I did Monday through Friday. I reached back into the Tahoe, grabbed my jacket and slipped it on. The gold star on my chest caught the morning light. The guard nearest Luis stopped moving. His face changed instantly. "Federal Marshal?" he whispered. Cynthia glanced at the badge, then at the government plates on my vehicle. For the first time, her confidence cracked. I walked toward my men. "What happened?" Luis swallowed hard. "They came through the east gate about 20 minutes ago. Said they had authority to detain us for interfering with a federal property seizure." My eyes narrowed. "A federal property seizure?" One guard lifted a document. "We have a warrant. Show me." He hesitated. Cynthia stepped between us. "You don't need to interfere, Mr. Mercer. Your employees were obstructing an authorized enforcement action." I stared at her. "You know my name." "Of course I do. This is your property." "Then you should also know there's something very wrong with what you just said." I took the paperwork from the guard. The moment I saw the seal, my stomach tightened. United States District Court. Federal Seizure Order. Marshal Service Execution Authorization. And at the bottom of the page was a case number I recognized immediately, because I was the supervisory deputy U.S. Marshal assigned to execute it. I looked up slowly. "Where did you get this?" Cynthia folded her arms. "Our legal department obtained it." "No." My voice came out quieter than I expected. Everyone went still. "This warrant does not authorize you to arrest anyone." One of the guards shifted nervously. Cynthia's jaw tightened. "It authorizes enforcement. It authorizes federal marshals to secure evidence at a commercial storage site 15 miles from here." I held the document up. "This ranch isn't listed anywhere." Luis stared at me. Cynthia said nothing. Then I noticed something else. The second page had been altered. A property description had been inserted beneath the judge's signature. My property description, my parcel number, my ranch. I looked directly at Cynthia. "Take the restraints off my men." Her face hardened. "I don't think you understand who you're dealing with." I reached for my radio. "No, Ms. Vale." My thumb pressed the transmit button. "I think you're about to understand exactly who you're dealing with." And then I called the federal team whose warrant she had just forged. People in Red Creek usually assumed ranching was my full-time life. I never corrected them. The truth was, I had spent 23 years with the U.S. Marshal Service, most of it handling fugitive operations, federal warrants, and court security across Wyoming and neighboring states. The ranch was where I came home to remember who I was before badges, case files, and armed teams became normal. My grandfather bought the first 400 acres in 1958. My father added more over the years. By the time the land passed to me, the Mercer Ranch covered nearly 1,200 acres of pasture, timber, creek beds, and open Wyoming sky. I could have sold it. Developers had offered enough money to make retirement easy. I refused every time. Luis once asked me why. We were repairing a fence near the western ridge when he said, "Boss, you know what somebody would pay for this view?" I hammered a staple into the post. "Probably more than they should." "You ever tempted?" I looked across the valley. No. That answer never changed. Then Red Creek Estates appeared. 2 years earlier, a development company bought land along my eastern boundary and built nearly 90 expensive homes behind stone entrance pillars and decorative fencing. At first, we barely noticed them. Then the letters started. One complained about cattle noise before 7 in the morning. Another claimed my equipment shed damaged community aesthetics. A third demanded that I stop using a dirt access road that had served my ranch for more than 40 years. I threw most of them into a drawer. Then Cynthia Vale became HOA president. That was when the tone changed. One afternoon, I found her standing outside my east gate, wearing a cream-colored blazer and holding a clipboard. "You're Daniel Mercer. That depends who's asking." She smiled without warmth. "Red Creek Estates has concerns regarding shared boundary activity. We don't share property, we share proximity. That's not the same thing." Her smile disappeared. "We'd prefer cooperation." I leaned against the fence. "And what does cooperation mean?" "For starters, restricting commercial ranch traffic on Willow Access Road. That road belongs to my property. Our attorneys disagree." I stared at her for a moment. "Then your attorneys should check the county records." She closed the clipboard. "This area is changing, Mr. Mercer. You may find it easier to adapt." I watched her walk away. Something about the way she said it stayed with me. 3 days later, Luis called while I was in Cheyenne. "Daniel, somebody put new survey stakes along the east pasture." I straightened in my chair. "County markings?" "No." He paused. "They've got Red Creek Estates printed on them." That was the first moment I realized the HOA wasn't complaining about my ranch anymore. They were measuring it. I pulled those survey stakes out myself the next morning, not because I was angry, because they were on my land. Every county map, deed record, and recorded easement I had ever seen put the eastern boundary exactly where my grandfather had marked it decades earlier. So when a silver Mercedes stopped beside the pasture fence around noon, I already knew who was inside. Cynthia Vale stepped out with 2 men in suits. One carried a leather portfolio. The other introduced himself as Martin Keene, attorney for Red Creek Estates. Cynthia looked at the survey stakes stacked in the bed of my pickup. "You removed association markers. They were trespassing." Keene opened his portfolio. "Our position is that this strip of land falls within a disputed access corridor." "There is no disputed corridor." "There is now." I stared at him. "That's an interesting legal strategy." Cynthia stepped closer. "You keep acting like this is some little disagreement, Mr. Mercer." "It is little." Her eyes narrowed. "Then why are you making it difficult?" I pointed toward the subdivision. "Because your HOA ends at that fence." Keene handed me a document. It was titled Notice of Boundary Enforcement. The language was aggressive enough to look official, but vague enough to avoid saying who had actually authorized anything. Then I reached the last paragraph. They were demanding temporary access to nearly 40 acres of my eastern pasture. "For what?" Cynthia answered. "Road expansion." I looked up. "Whose road?" "A future community connector." "Across my ranch?" "Across land we believe is subject to shared access rights." I laughed once, not because it was funny, because it was absurd. "You built a subdivision next to a working ranch, and now you think that gives you a highway through it." Cynthia's expression went flat. "You're standing in the way of progress, and you're standing on private property." Keene raised a hand. "Threats aren't helpful." That wasn't a threat. I pointed toward their car. It was directions. They left 10 minutes later. But Cynthia wasn't finished. Over the next 3 weeks, everything escalated. My ranch trucks were photographed every time they used Willow Access Road. HOA security vehicles started parking near my gate. Luis caught 2 guards filming cattle operations from inside the fence line. Then complaints began appearing with the county. Alleged runoff violations, excessive commercial traffic, unsafe fencing. Every one of them was either dismissed or forwarded for clarification. Cynthia responded by getting louder. One Friday evening, I was closing the equipment barn when an HOA security SUV rolled up behind me. The driver lowered his window. "You Daniel Mercer?" "You already know I am." He handed me a folded notice. "Effective immediately. Red Creek Estates is restricting access through the eastern corridor. You don't own it. We've been instructed otherwise." "By whom?" He looked toward the passenger seat. Nobody answered. I unfolded the paper. At the bottom was a reference number. Not county, not state. Federal. My pulse slowed. I had spent enough years reading government filings to know the difference between sloppy paperwork and something deliberately designed to look official. I called my office in Cheyenne. "Run this number for me." 30 seconds later, the clerk came back. "Daniel, that case is active." I stared at the notice. "What kind of case?" "Federal seizure warrant." My hand tightened around the paper. Then she added something that made the entire situation shift. "It has nothing to do with your ranch." I stayed on the phone with the clerk. "Read me the target location." She paused, keys clicking in the background. "Northgate Industrial Storage, Unit 14. Property seizure related to an interstate fraud investigation." "County?" "Laramie." I looked toward my pasture fence. Red Creek was nowhere near it. "Any mention of Mercer Ranch?" "No." "Willow Access Road?" "No." "Red Creek Estates?" Another pause. "No." That was enough for me to stop treating the HOA notices like harassment. Someone had taken a real federal case number and attached it to their own paperwork. That crossed a line. I drove into Cheyenne that evening and met Rachel Morgan, an assistant U.S. attorney I had worked with for nearly a decade. Rachel was 46, sharp-eyed, patient, and almost impossible to impress. She read the HOA notice twice, then she placed it flat on her desk. "This didn't come from us, I know. The seal is wrong." I leaned closer. She tapped the bottom corner. "See this spacing? Federal filings don't format certifications like this." She turned the page. "And this language, authorized community enforcement personnel, doesn't exist in the warrant. So somebody copied the case information." More than copied. Rachel opened the actual federal filing on her computer. We compared them line by line. The HOA document used the correct case number, the correct judge, the correct filing date, even the correct federal district. But 3 paragraphs had been added. Those paragraphs claimed that authorized agents could secure land connected to the investigation while awaiting federal execution. My land description had been inserted beneath them. Rachel leaned back. "That's not amateur work." That bothered me more than I wanted to admit. The next morning, I hired Caleb Turner, a licensed surveyor who had handled rural boundary disputes for 30 years. We walked the eastern pasture together. Caleb checked county plats, deed history, easements, and the old survey markers my father had used. After 2 hours, he stopped beside one of the new stakes Cynthia's people had driven into the ground. "This line is wrong by almost 300 feet. Accident?" He shook his head. "Not with modern equipment." He crouched and brushed dirt from the marker. "They shifted the boundary intentionally." 300 feet might not sound like much. Across the length of my eastern property, it gave the HOA almost 42 acres. Exactly the land Cynthia wanted for her connector road. Then Luis brought me something else. "I found this on the barn camera." We opened the security footage. At 2:13 in the morning, an SUV entered through the east service gate. 2 men got out. One was wearing an HOA security jacket. The other carried a surveying case. They crossed into my pasture and disappeared beyond the camera angle. I froze the frame. "Recognize him?" Luis leaned closer. "No, I did." The second man was Martin Keene, the HOA attorney. Rachel called me that afternoon. Her voice was different. "Daniel, I found something you need to see." "What?" "A payment record tied to the development company." My grip tightened around the phone. "To who?" She hesitated. "Someone with access to federal court documents." That was the moment this stopped being a land dispute. Someone inside the system had helped them. Rachel sent the file through a secure federal channel. I opened it at my kitchen table just after midnight. The payment came from Frontier Crest Development, the company behind Red Creek Estates. Recipient, Elias Warren, a contract records technician who occasionally handled archived federal filings. Amount, $18,500. Description, consulting services. I called Rachel immediately. "That's our leak." "Potentially. Internal Affairs is already involved." "What exactly did Warren access?" "We pulled his system history." I heard papers moving on her end. "He opened the Northgate warrant 6 times in 2 weeks. He had no assignment connected to the case." My jaw tightened. "And after that?" "He downloaded the signed PDF. There it was, the missing piece. Someone at Red Creek Estates hadn't invented a fake warrant from scratch. They had obtained a real one, altered it, and wrapped their property grab inside federal authority. But Rachel had found something worse. "Daniel, check the second attachment." I opened it. It was an email chain recovered from a Frontier Crest executive account. Martin Keene's name appeared near the top. Then Cynthia Vales. I started reading. If Mercer refuses voluntary access, the federal documentation should create sufficient pressure. Security can establish temporary control before he gets counsel involved. Another email followed. Once the corridor is physically secured, construction mobilization needs to begin immediately. Possession will strengthen our negotiating position. I sat back slowly. They weren't trying to win a boundary argument. They intended to manufacture possession. Get equipment onto my land, control the road, start construction, then force me into years of litigation, while the subdivision expanded around me. Rachel spoke quietly. "This is conspiracy evidence." I stared at Cynthia's name on the screen. "She knows the warrant is altered. Looks that way." The next morning, I told Luis nobody worked alone near the eastern boundary. Then the attack came. At 6:42 a.m. he called me, not speaking, shouting, "Daniel, they're inside." I was already grabbing my keys. "What happened?" 6 security guys. "They've blocked the road. They're saying federal seizure. Don't resist them." "They put Evan on the ground." My pulse hammered. Luis, listen to me. Nobody fights. Nobody reaches for anything. I'm coming. By the time I arrived, my ranch crew was detained, and Cynthia was standing beside them, with the forged warrant in her hand. That was the scene I had walked into, the scene that started this whole story. Only now, I knew exactly what she had done. I radioed my federal team. Red Creek Ranch, priority response. Possible impersonation of federal authority, unlawful detention, forged judicial process. One HOA guard went pale. Cynthia stepped toward me. You're trying to intimidate us? No. Sirens sounded somewhere beyond the ridge. She glanced toward the road. I held up the altered warrant. You used a federal judge's signature to seize private land. Her lips parted, but nothing came out. Then 3 government SUVs appeared through the dust. Behind them came 2 sheriff's units. I looked at Luis. Court comes next. He nodded slowly. And as the first federal agent stepped out, Cynthia finally realized we weren't going to be arguing about HOA rules anymore. We were going to be arguing about felonies. 6 weeks later, I sat behind the prosecution table in the federal courthouse in Cheyenne and watched Cynthia Vale walk into the courtroom without looking at me. She looked different without the tailored blazer and HOA entourage, smaller somehow. Beside her sat Martin Keene and an attorney from Denver who had spent most of the morning whispering into his ear. The charges had moved fast: conspiracy, falsification of federal records, unlawful detention, and impersonation of federal authority. Elias Warren had already agreed to cooperate. That was the part Cynthia clearly hadn't expected. When Warren took the witness stand, Martin stopped taking notes. The prosecutor approached him. Mr. Warren, did you provide a federal warrant to representatives connected with Frontier Crest Development? Warren swallowed. Yes. Were they authorized to receive it? No. Why did you provide it? He stared down at his hands. I was paid. A murmur moved through the gallery. The prosecutor displayed the $18,500 transaction. Then came the emails. Cynthia's own words appeared on the courtroom monitor. Security can establish temporary control before Mercer gets counsel involved. Her attorney stood immediately. Objection. Context. Overruled, the judge said. I watched Cynthia's face. No reaction. Then the prosecutor showed the altered warrant. The original appeared beside it. Same case number, same judge, same signature. But the forged version contained 3 additional paragraphs and the legal description of my ranch. Deputy Marshal Mercer, the prosecutor said later. When did you first realize the document had been altered? I was on the witness stand by then, when I compared it to the warrant assigned to my team. Did that warrant authorize HOA security personnel to detain anyone? No. Did it authorize seizure of Mercer Ranch? No. Did it authorize Frontier Crest Development to take possession of any land? No. The prosecutor paused. Then what authority did the defendants have? None. Martin's attorney rose for cross-examination. Deputy Marshal, you're also the property owner here. Yes. So you have a personal interest in this case. I have an interest in people not forging federal warrants. A few people in the gallery shifted. The judge looked over his glasses. Answer only the question, Marshal. Yes, Your Honor. The attorney walked closer. Isn't it possible Red Creek Estates genuinely believed the warrant gave them enforcement authority? No. You can't know what they believed. I know what they were told. He stopped. I continued. 3 days before my workers were detained, I informed their security supervisor in writing that the document did not apply to my ranch. The courtroom went silent. The prosecutor stood. Your Honor, may we introduce Government Exhibit 37? My email appeared on the screen, time-stamped, delivered, and forwarded minutes later to Cynthia Vale and Martin Keene. The subject line read, Notice. No federal authority exists for Red Creek Estates action. Cynthia finally looked at me. The prosecutor turned toward her. You received that warning, Mrs. Vale. She took the stand that afternoon. I believed Mr. Mercer was protecting his personal property by misrepresenting federal procedure. So you ignored a supervisory deputy U.S. Marshal? I relied on counsel. Martin's head snapped toward her. The prosecutor noticed. So Mr. Keene told you to proceed. Cynthia froze. Martin whispered something furiously to his attorney. The judge leaned forward. Mrs. Vale, answer the question. Her confidence disappeared. Yes, Martin stood. That is false. Sit down, Mr. Keene, the judge ordered. Then the prosecutor placed one final email on the screen. It was from Martin to Cynthia, the night before the raid. Proceed tomorrow. Once the road is secured, Mercer will have no practical choice but to negotiate. Nobody spoke. The judge removed his glasses and stared at both defendants. "I have heard enough." My stomach tightened. He looked toward the clerk. "Bring everyone back at 9 tomorrow morning." Then he rose. "I will issue my ruling then." At 8:57 the next morning, the courtroom was already full. Reporters lined the back row. Several Red Creek Estates homeowners sat together near the aisle, whispering until the courtroom deputy called everyone to order. Cynthia entered first. Martin followed several steps behind her. Neither looked at the other. When the judge took the bench, every chair stopped moving. He opened a thick folder. "The question before this court is not whether the defendants had a disagreement with Mr. Mercer over land." He looked directly at Cynthia. "Property disputes happen every day." Then his eyes shifted toward Martin. "What does not happen every day is the deliberate alteration of a federal judicial warrant to manufacture authority that does not exist." Martin lowered his head. The judge spent nearly 20 minutes reviewing the evidence. Elias Warren's payment, the altered property description, the security footage, my written warning. And finally, Martin's email ordering Cynthia to proceed after they knew the warrant did not apply. Then came the words everyone had been waiting for. "On the counts tried before this court, I find the evidence establishes guilt beyond a reasonable doubt." Cynthia's shoulders dropped. Martin closed his eyes. Behind me, Luis exhaled so loudly I heard it from 3 rows away. The judge wasn't finished. Their sentencing hearings would come later, but both defendants were immediately placed under strict release conditions pending sentencing. Federal prosecutors also confirmed that Warren's cooperation would be considered separately. The criminal case triggered consequences outside that courtroom almost immediately. Frontier Crest suspended the Red Creek expansion project. Its lenders froze additional funding. The county opened its own review into the manipulated boundary filings, and Red Creek Estates called an emergency HOA meeting that same evening. I didn't attend. Luis did. He came to my ranch afterward carrying 2 coffees and wearing the biggest smile I had seen in weeks. "You're going to like this." "What happened?" "They removed Cynthia." I stared at him. "Already?" 78 homeowners showed up. He handed me a coffee. Apparently people get pretty angry when they learn their HOA dues may have helped finance a fake federal land seizure. Within a month, the board formally withdrew every claim against my property. The false survey markers disappeared. The proposed connector road was abandoned. My attorney also secured a civil settlement covering the damage to my property, legal expenses, and compensation for Luis and Evan over their unlawful detention. But the moment that mattered most happened quietly. No cameras, no reporters, just me standing near the east pasture while Evan repaired the same gate where he had been forced onto the ground. He tightened a hinge and looked over at me. "You think they'll ever try something like that again?" I looked toward Red Creek Estates. "I think they learned something." "What?" I rested my hands on the fence. "A piece of paper only has power when the law stands behind it." Evan nodded. "And when somebody fakes the law." I looked at the ranch stretching behind us. Then eventually the truth catches up. For the first time in months, the east gate closed without anyone waiting on the other side. 6 months later, the ranch looked exactly the way it had before Red Creek Estates decided they could take a piece of it. The cattle still moved across the eastern pasture at sunrise. Luis still complained about my coffee. Evan still left tools in places he swore he would remember. And every morning when I drove past that east gate, I thought about how close arrogance had come to becoming theft, simply because someone believed official-looking paperwork would scare ordinary people into surrendering. That experience taught me something I had learned many times wearing a federal badge, but somehow understood differently when my own land was involved. Authority should never be accepted blindly. A uniform, a seal, a title, or an intimidating letter does not automatically make someone right. Ask questions. Read the documents. Know what you own. And when something feels wrong, don't let fear make your decisions for you. My family protected this ranch for generations. My responsibility wasn't just to hold on to the acreage. It was to make sure the people who came after me understood why standing your ground sometimes matters. If you've ever dealt with an HOA that crossed the line, tried to control your property, or used intimidation to pressure you, tell me your story in the comments. What would you have done if armed HOA guards showed up carrying a federal warrant with your property written into it? If you enjoyed this story, hit like, subscribe, and turn on notifications for more stories about property rights, HOA conflicts, and people who refused to be bullied. Thanks for watching. And remember, when someone claims they have authority over your home, make them prove it.